Okay, the next case set for hearing this morning is Balawender versus Mulroy. It's case number 19CA011474. I recall there were children involved in this case, so the courts, because we videotape these arguments, we ask that you refer to children just by initials only. We've read the briefs and are ready to proceed if you want.
Thank you. I will reserve 5 minutes for rebuttal.
Thank you for reminding me that you do have rebuttal. 5 minutes, thanks.
Joseph Stafford on behalf of Teresa Mulroy. This is actually the second time I'm before, I believe, 2 of the 3 who is the panel today. This matter was once before brought before you. A decision was rendered back in November of 2017, reversing the trial court's decision. The reason why I raise this is in order to understand the complexity and the difficulties of this case, you have to look at the prior case this court handled. There was an agreement back in 2016. Parties reached an agreement on the record. The court is saying it's going to resolve a couple minor issues and reach a decision. The court in the domestic case says she's going to issue a decision, and she doesn't. Until opposing counsel sends to her ex parte a judgment entry which she signs, carte blanche. That is from which we appealed the first case to you in which you reversed. The second assignment of error, which the court found was moot, was we claimed that the court merely rubber stamped what opposing counsel submitted. The problem then happens after your dismissal. The trial court does not follow the remand for almost 11 months. It takes the court 11 months to finally issue its remand order, which was quite simply a matter that should have been dealt with very quickly. Unfortunately, when the court reversed the trial court's decision, the father in this case and his counsel in the trial court believed the trial court's decision was still valid and enforceable. But contrary to that, the parties were reversed back to the 2013 judgment entry. This court reverses a trial court's decision. It goes back to the last order of court under domestic relations law. The trial court, the father in that, took a different view, and what the problem was then, there is difficulties between the parties, and then prior to the court's decision, this petition of domestic violence gets filed in September of 17. So in September, there's a petition for domestic violence filed, which is granted. The court thereafter finally follows the remand in October. Then in January, eviscerates that whole decision by rendering moot the prior orders of court. And I say that because what the most confusing part of this case is, and what I hope the court does not get lost in, is the difference between domestic violence under 3113.31 and Ohio Revised Code section 3109.04. Those are completely different statutory provisions. Unfortunately, the trial court believed that under domestic violence, you can use 3109.04 to do certain things to make a determination. At the ex parte hearing on the petition for domestic violence, the trial court, the magistrate hearing it, actually makes a determination and makes a statement. He's never done this before, where there's never been any showing of domestic violence, but nevertheless, he's going to give the person a protection order. He says that on the record. Then this case, my client retains different counsel to handle this matter. I was out on an extended vacation. My colleague files a motion to dismiss, which is denied, and goes to full evidentiary hearing. The court reassigns the case back from the magistrate to her, and she's going to hear the case. Now, what's troubling about this is that there were issues in the domestic relations case which we thought were very unusual. After the court signed the ex parte order presented by Mr. English to the court recused itself from the case. And it said, due to a personal consultation with Mr. English concerning her personal matters, there's a blanket recusal. Okay, I understand that. And then the trial court, what the trial court did later in 10 days, was rescind that order and said, due to her resolution of her personal matter, there was no longer a basis to recuse herself from the case. We filed and was pending before the court in February a motion for disqualification of counsel and a motion for the court to recuse itself from the proceedings. On the one hand, you can't tell parties there's a conflict. The other hand, merely 10 days later, you reconsider it, and then you're going to hear the matter. What is also very unusual about this, when you look at the statutory scheme of domestic violence under 311331, you have to look, was there actual harm committed, or was there immediate threat of harm under the statute? Well, that clearly wasn't the case under the fact pattern of this. This fact pattern starts on the afternoon of September 14th, 2018, when father decides he's going to deny visitation to mother because she didn't respond to an email on our family wizard. From there, it transcends to parties going over to the other one's home, police being called, and the police getting involved later in the evening. That doesn't rise to domestic violence. The notion that the court did was come under menacing by stalking under 2903.211 of the revised code, and indicates something along the lines that because of this behavior that occurred, posting on social media and also showing up at the residence and photographs being taken and whatnot, that somehow this created domestic violence. What's peculiar about this, the father said the posting of his address on social media caused him to fear for his safety. Well, that simply begs common sense. One, his address is on this court's docket, the common pleas docket. Number two, it can clearly be found in the auditor's office. And number three, when you look at my colleague's statement of the case, in the very first statement of his facts, he puts his own client's address and lists it out in his statement of the case. So how is where the known residence of a person being posted anywhere is domestic violence does a disservice to true victims of domestic violence. The notion that this behavior that the court looks at rises to the level of domestic violence and issuing a protective order, a 5-year protective order on top of it, simply begs common sense. It's a perversion of the law. And I don't say that lightly, because the perversion comes as follows. So you issue the order, but then you name the children as protective parties. Okay, they're protective parties. But then what the court does is go in and determine that the prior order of courts will be set aside, designates the father the temporary residential parent for 5 years, limits mom's contact to supervised telephone contact. That's what the order says. So the idea that there's domestic violence between the parents is one thing, but there was no showing of violence to the children, and let alone how do you modify custody orders in a domestic violence setting when you determine that somehow you're going to designate, you destroy the shared parenting plan, you say mom's only contact will be by supervised telephone contact, no more in-person contact, and on top of that you say she needs counseling. What is troubling about this, and I really have not seen this before, is that the court decides to do an in-camera interview of the children. Now, sitting here, and I know you, listening to arguments, this panel covers a variety of areas of the law. But in a domestic relations case, this is a very specific provision. The court can only interview the children under 310904 to determine their wishes and desires for the placement or the allocation of parental rights responsibilities. The statutory scheme does not permit a court to engage in an in-camera inspection of the children in a domestic violence setting where, one, there's no guardian ad litem for the children, and two, there's no record kept of it. So, and the court premised its decision, when you read its decision, upon that in-camera review as well as the testimony. There is no statutory scheme in Ohio law or Ohio case law that permits in a hearing on domestic violence that the court can do an in-camera interview of children. It is just prohibited by law, but the court nevertheless did it.
Was there an objection to that?
Well, interesting, if you look and concentrate on when the court says this, it's after the closing statement made by counsel. She says it in her statements on the record, starting at page 285 through about 299, is cause alone for this court to reverse the trial court's decision. The statements made by the trial court should not have been made. She basically considered what, and the reason why I say this is that she says it in there, she's going to interview the children. And if you look at the harmless error rule of Ohio Rule of Evidence 103D, this is error on its face. It's contrary to law, it's not permitted, there need not even be an objection made, and she makes the statement she's going to interview the children. When evidence is closed, an argument has already happened, and it's in that setting in which she interviews the children. Yeah, there's no record of it.
Let me pause you for 1 second, because you're at 5 minutes. You can continue if you'd like, but it'll be.
I'll keep my rebuttal open to my 5 minutes. My request is this court to reverse and to deny the motion and dismiss the petition for domestic violence. There is little confidence we have at this point that the trial court's going to follow your mandate, because the trial court failed to follow your mandate in a timely fashion before. Thank you.
You? Almost afternoon, so I'll still say good morning, but you've got 15 minutes.
May it please the court, my name is Brent English. I'm here on behalf of the appellee, Walter Balawender III. To initially respond to Mr. Stafford's claims, I think that what he has offered to the court is essentially a red herring with respect to the trial court's alleged failure to comply with this court's mandate. This court reversed the prior decision on two very specific grounds, neither of which addressed the issue of the allocation of parental rights. One related to, in particular, to whether or not my client could move to a different location within Lorain County, and whether he was limited to one move before he could, without having to request authority from the court. Nevertheless, that ship has sailed, and ultimately the court has issued a judgment based after the remand order. However, as I said, that's a red herring because we are really here on a domestic violence civil protection order issue that occurred in September of 2018. Mr. Stafford said absolutely nothing about the facts of the case, and I know the court has read the briefs, so the facts of the case are really not anywhere close to as benign and absurd as he would suggest. But the fact of the matter is that there was clear evidence in this case of menacing by stalking, which is one of the statutory provisions for a domestic violence civil protection order. That evidence showed that the children suffered mental distress, considerable mental distress as a result of the conduct of the appellant, as did my client, as did his wife, who is a family and household member. There is no doubt that happened. And this is not as absurd as simply claiming that, well, because my address was published on the internet, that somehow that constitutes menacing by stalking. Of course it doesn't. No one would suggest that. However, when you take a videotape of a person's residence and show what it looks like and identify where the children sleep at night, that becomes very problematic. And the parents testified in this case, the stepmother testified in this case, and everyone knew that this was a significant problem. But that's not the half of it. In this case, we had Teresa Mulroy, the appellant in this case, chasing my client and his family, including the children, all around the city of Grafton, right back to back on his car as he tried to avoid them on 13 separate streets in the city of Grafton over a period of about 20 minutes. Did this constitute mental distress? Yes, it did. And that's exactly what the evidence was.
Counsel, is mental distress the test?
Yes, Your Honor. It's one of the tests under the, that is an element of civil, of menacing by stalking. In order to establish menacing by stalking, you have to show that there was some degree of mental distress. You do not have to show there's any professional treatment that was required, but that was simply reasonable under all the circumstances.
Is there also a requirement that they show by preponderance of the evidence that there was a belief that physical harm would be caused by
Yes,
the opposing.
yes, there is.
Both
And-
parties.
And Walter Balawender testified to that. That's a matter that the court had to make the decision about whether or not his testimony was credible or not credible. And obviously, the court found the testimony to be highly credible. So in this situation, this is not a matter of anything to do with the underlying domestic relations case, but rather the court being confronted with conduct of a party that was reprehensible on its face, was clearly violative of the statute, in which the court had every right and indeed an obligation to protect these parties from. So Mr. Stafford contends in this case that the court should not have interviewed the children. There is no prohibition in the statute that prevents the court from doing so. There is a case that he has cited that says that the court that denied relief when a party objected to not having a child interviewed, and the court held that it was not going to interview the child. In this case, however, the court made it clear that it was intending to interview the children. There was no objection expressed whatsoever. And in fact, that occurred. You cannot, at the last minute, particularly in a court of appeals brief, contend that this somehow violates due process and that the doctrine of harmless error should apply. Those words are never spoken in any of the briefs filed by the appellant. However, today they come before you recognizing that their argument is completely without merit and contend that instead this should just be a concept of harmless error. Courts rely upon the parties to make appropriate objections at the appropriate time, and in this case, no objection was made, assuming, although not conceding, that the trial court did not have it within its authority to conduct an in-camera interview.
So there would have been an opportunity to object?
Surely there would have been an opportunity. Not only was the appellant represented when the court said it was going to conduct an in-camera interview, the time to have said that is, I object, or to file something with the court before the in-camera interview took place, indicating that the court allegedly did not have statutory jurisdiction.
So this wasn't a situation where I might have been misunderstood, where a court reporter had left the room and there was just a discussion after they...
Not at all. It's all part of the record.
Okay.
It's all part of the record. The question in this case is whether or not there is some competent, credible evidence to support the trial court's decision. That's the legal standard here. It's a civil manifest weight argument. It's not just some mishmash of, well, it's unfair and it's unprecedented and on and on. The issue that this court needs to look at simply is whether or not the record supports what the trial court did. And the trial court, although it issued a 5-year CPO, also said that if the respondent, in this case Teresa Mulroy, does certain things, the court retained jurisdiction to modify that order, and of course it has that jurisdiction anyway under the statute, and specifically invited that to occur.
Under, just so I'm clear, the retention of jurisdiction under the statute, are you referring to the domestic relations statute, or are you referring to?
No, I'm referring to the domestic violence statute. There is a specific provision in the domestic violence statute that permits a party to seek to modify the existing CPO. And in fact, there was a specific hearing date set. But because of this appeal, that review hearing did not take place.
So, to the extent that the trial court in this particular domestic violence case issued an opinion as to the custodial status of visitation of something that was in the domestic relations case pending at the time, by retaining jurisdiction, would that create a situation where we just can go back and forth between the domestic relations case and the domestic violence case?
No, Your Honor, if there's a modification of the CPO, the modification would be to terminate the CPO or to extend it depending upon the circumstances. In this case, we have a custody order. There's a shared parenting plan that's in place with a specific parenting schedule, but the court made a determination that because of the domestic violence that occurred in this case, that that parenting schedule should be suspended until such time as the conditions are set forth in the CPO are met. I think the court has every justification for doing that, and I don't think that creates a conflict between the parenting order and the civil protection order at all. Otherwise, you could have toothless CPOs because there's an existing shared existing parenting order.
Or
And
you could have toothless shared parenting orders.
Well, the bottom line is, what is in the best interest of these children, and do they need protection from an act of domestic violence that was clearly proven in this case? And the answer to that was, yes, they did, and the court then exercised appropriate judgment in deciding what those orders should be. There was no reason to believe that absent a complete cessation of physical contact with these two girls, this conduct was going to stop. There is a pattern of conduct that was so reprehensible, and if you look at the exhibits that are in the record, you will see this is a person who is completely out of control. She will do and say whatever it is that she wants to say and enlist all of her Facebook friends to pile on and creating all sorts of difficulties for these children and difficulties for her ex-husband, none of which is necessary and all of which is harmful.
Can we go back for a minute to the mental distress caused by the actions? Was there testimony of the respondent, as to his substantial incapacity or mental condition which would normally require treatment even though he may not have sought treatment?
Yes.
What was that testimony?
He said that he was so afraid for his safety that he immediately went to the police, and that this conduct of Mrs. Mulroy in doing what she did in this situation created that circumstance.
So the testimony that goes to substantial incapacity or mental condition was, I went to the police.
Well, no, it was, I was very afraid for my health and my safety and for the health and safety of my children as a result of her conduct. I think that is sufficient under the menacing by stalking statute. If you look at the case law, which I have cited extensively in my brief, I think it's pretty clear that you do not have to establish that the mental distress rises to the level that you need treatment for it, or it is so incapacitating that you cannot sustain it. That's a matter for the trial court to make a determination about, and if there is sufficient evidence in the record, some competent, credible evidence to support that, the judgment should be sustained. Thank you. I ask you to affirm. Thank you.
Thank you. 4 minutes, 54 seconds left for rebuttal.
Thank you. I would like to pick up where the questioning left off. What the problem is that the court didn't understand the standard under 31-1331. And I say that because it's really simple to determine the court didn't understand the standard if you look at her decision. On page 2 of the findings, and she says, the court hereby makes the following finding. Based upon the testimony and the evidence presented, court finds that respondent did engage in a pattern of conduct which caused distress to petitioner for his and his family's safety. That's not the standard. It's mental distress on one hand, or the offender caused the other person to fear for physical harm likely to occur. The court just didn't follow the standard, and she makes these findings blurring the two. It's either or, and she blurred the two, and it didn't make any sense whatsoever. And if that's her findings, it clearly calls for a reversal of the trial court's decision, because that's not the law. And what's troubling about this in-camera review, I would ask the panel to think if they've ever seen a case, a civil case, which a petition for domestic violence is, where the court can say in front of a jury or a bench trial, I'm going to interview a witness outside of the presence of lawyers, outside of the children's representative, and I'm not going to do a record of it, and I'm going to question witnesses and make my determination upon that particular determination. That clearly is a reversible error on its face. No civil case is a judge permitted to do that. And that's what occurred in this case. And then the court abolished the shared parenting plan. There's no other way the court did it other than by doing this. And the reason why I'm concerned what the judge said and why I want you to dismiss this petition, not only reverse, but to dismiss the petition, is because what the court said on page 292 of the transcript. She says, I'm in Canberra with these children. I thought I promised the children I will not divulge what was said. I can tell you, Miss Mulroy, you were never going to have shared parenting. You're never going to have that midweek overnight. That's the point. I was at trial, and I believe I may have told Mr. Stafford in English that off the record. As they were standing in the back, she got it because Mr. Balawender and Mr. English agreed to it. They came up with this agreement, and then I was supposed to decide two things. And then when I was looking at it, it didn't look like I just wanted to decide those two things. I wanted to go with what I was going to do, which would have been no shared parenting. Mr. Balawender would have had the residential parent and legal custodian. The court says that of a prior proceeding in this proceeding, and that's on page 293. And then this issue of in-cameraing the children occur on line 12. I'll in-camera the children, most likely, and continuing the CPO on Mr. Balawender. She's already made a determination even before interviewing the children. My client has no other hope than this panel. And I say that because now she's been deprived of seeing her children in any meaningful shape for almost 2 years now. The first reversal, it was meaningless. The court didn't follow the mandate, didn't do anything to assist the parties, and made more of a mess by not issuing a decision. And then, here we are once again. My client has no contact with her children, except for supervised phone contact. Whatever that may be, that's horrendous. It's horrific for any parent to have that, and there's no justification for it under a best interest standard. The only way the court can do this is under domestic violence statute. Under a best interest statute, under 310904, you can't do something like this, and there's no end in sight. How is that fair? How is that due process? There is no due process.
I want to, so I don't misapprehend your argument. I apologize if I didn't ask this before
Sure.
your rebuttal, but why is the last assignment of error related to the ex parte granting of the DBCPO not moved? Because we're only in the, you can't make up visitation time, we're only in the DB. I don't want to.
It's there because, for us as practitioners, if in fact you say there's no domestic violence and you grant it, and then it's going to be heard by the magistrate and the judge comes in and pulls it and says, I'm going to hear this, it should never have started. That's why it's there, for the practitioners, everyday lawyers and everyday individuals that handle this. And it may be moved, and I'll concede that. But it's there because it should never have started. If a fact finder says there's no domestic violence here, but I'm going to give it to you anyway, what's the purpose of having that? And then we're off to the races, and then my client is left with a burden, and the court kind of switches the burden to my client. And then the court just goes off and doesn't follow the statute, and then terminates her rights. She has no rights currently, other than supervised visitation. Shared parenting's gone. How is that possible? And the idea.
I did want to let you answer the question, but your time has expired.
Thank you.
Thank you both for your arguments today. The court will take the matter under advice and issue its decision. You will get copies of the decision mailed to you by the clerk of the court as on the day it is released. You can also find the court's opinions on the Supreme Court Ohio's website where they are posted. The court wants to thank both of you for coming down today and providing us with those arguments.